Good evening, everybody. Welcome to this Inquest Law webinar series. This is Inquest Law Overview Part 1, Basics of Inquest Law, focusing on the recent reforms and procedural aspects. And thank you very much for joining. So my name is Samantha Broadfoot-Casey, and I will chair the session today. In terms of my background, I practice in a broad range of public law, and I have done inquest work for many years, particularly in front of juries and often involving systemic issues like roads, road safety, air and marine safety, as well as hospital-related inquests. I am also an assistant coroner for Cambridgeshire and Peterborough, and so have the benefit of seeing things from the other side, as it were. I am joined in this talk today by my colleague in Chambers, Harriet Wakeman, an experienced inquest lawyer. Harriet practices in inquests and public inquiries, public law and planning law. She's recognised as a leading junior for inquests and public inquiries in both Chambers and Partners and Legal 500. She acted as counsel to the inquest in the Bougaled-Brez inquests, and she's currently instructed in the Dawn Sturgis inquiry concerning the Novichok poisonings and the Cranston inquiry concerning an incident in November 2021 when 27 people lost their lives crossing the Channel. This is part of a series of webinars, and so aspects not covered today may be covered in due course in another seminar, such as a scope of inquests and Article 2, these are examples, and let's crack on. And finally, we were supposed to be joined today by Catherine Elliott, but unfortunately some professional commitment came up and she's been unable to join us today, but I'm sure she will join us in another session. So let's crack on. Starting at the very beginning, a reminder of the sources of law for what can sometimes be quite a complex process. Obviously, you've got the primary legislation in the Coroners and Justice Act 2009, the Coroner's Inquest Rules 2013, case law, of course, but also not to forget the Chief Coroner Guidance, Advice and Law Sheets, which are all available on the link. Most deaths do not get referred to the coroner, but nonetheless, quite a lot do. The latest statistics publicly available, which is for 2022, indicated that 36% of all registered deaths were reported to coroners in that year, and 43% of those involved post-mortem examinations, which amounts to some 90,000 of them, and about 17% of all those reported to the coroner proceeded to an inquest. There is a list of circumstances in which deaths must be referred, and this is set out in the Notification of Deaths Regulations 2019, which we will come to shortly. The focus of my talk, however, is on the reforms which were given statutory effect on the 9th of September 2024. These require all deaths in England and Wales to be independently scrutinised either by a coroner or by a medical examiner. Part of the hope is that fewer deaths will end up being referred to coroners. So how did we get here? Some of you might remember the horrors of the GP serial killer Harold Shipman, who was arrested in 1998 and found guilty of 15 murders of his former patients. The government responded by setting up an inquiry chaired by Dame Janet Smith. The inquiry was tasked with investigating the extent of Shipman's unlawful activities, inquiring into the activities of the statutory authorities and other organisations involved, and making recommendations on the steps needed to protect patients for the future. The inquiry published a total of 6 reports and found major flaws in the processes of death registration, prescription of drugs, and monitoring of doctors. The inquiry also established that Shipman had killed at least 215 of his patients over a period of 24 years and may have killed as many as 300, although the true number apparently could even be higher. And for present purposes, it is the 3rd report which deals with death certification and the investigation of deaths by coroners, which is the background to the present reforms. Since 1926, the law required that before a death could be registered and the body disposed of by burial or cremation, the medical cause of death must be certified by a doctor who has attended the deceased during his or her last illness, or by a coroner after autopsy or inquest. The procedure for certifying the medical cause of death has remained virtually unchanged since 1926, which is obviously nearly a century ago. Now, the current procedure, or rather the current procedure until these reforms, had three very real advantages. It was speedy, it was cheap, and it was convenient. But it also obviously has a number of disadvantages. The most serious of these is that it's dependent on the integrity and judgment of a single medical practitioner. That medical practitioner, if he or she has attended the deceased during the last illness, must decide, excuse me, whether he or she should report the death to the coroner or whether she can properly proceed to issue the medical certificate of cause of death, which is known in the jargon as the MCCD. One of the circumstances in which a death should be reported to the coroner is if the death is sudden and the cause is unknown. Many of Shipman's patients died suddenly in circumstances in which no honest doctor could have claimed to know the cause of death. And yet Shipman, who had killed them, was able to certify the cause of death to avoid a report to the coroner and thus also avoid any official inquiry into the death. Once a doctor has fully certified the cause of death, then provided that they have completed the MCCD fully in appropriate terms, then there's no check on the truth or accuracy of what is stated. There's no system, or there was no system of audit or review of those cases where a doctor certifies the cause of death and does not report the death to the coroner. The relatives of the deceased person will take the MCCD to the register office and the death will be registered. And that's it. A burial can then take place without any further check or formality. The process where a body was to be released for cremation was also antiquated, and the regulations dating back to the turn of the last century. This introduced an additional safeguard where a second doctor would consider the MCCD and a somewhat fuller form that accompanied it. And the idea was that the second doctor would carry out his or her own inquiry and complete a confirmatory certificate. And then a medical referee on behalf of the crematorium would examine the forms and satisfy themselves that their forms were in order and that the cause of death had been properly and definitively ascertained. However, the Shipman inquiry discovered that none of that was working properly at all. The second doctor was often not remotely independent, was often quite junior, often nominated by the main doctor, did very little inquiry, and the exercise carried out by the medical referee at the crematorium was clerical only. The fees for the three professionals concerned came to just under £100 in total. And so Dame Janet proposed a radical overhaul of the system. Now, this has taken a very long time, and in the interim, there have been further investigations, inquiries, and reports. Mid-Staffs, the Morecambe Bay investigation report, the government response to the report of the Gosport independent panel, and eventually the reforms resulted in a system in which there would be an independent review to be carried out for all deaths in England and Wales without exception. And this will either be independent scrutiny by a medical examiner or investigation by a coroner. So the legislation underpinning these changes is set out on this slide. And it's the Coroners and Justice Act also enables governments to make regulations in several areas, and these regulations provide the detail of how medical examiners and the reformed death certification process will operate. And there are three sets of medical 3 sets of regulations, as well as a set of regulations from the Welsh government. There is also detailed guidance available at this link. So what are the reforms? There are 3 main changes. The first is that from September this year, a medical practitioner will be eligible to be an attending practitioner and complete the MCCD, the Medical Certificate of Cause of Death, if they have attended the deceased in their lifetime. The attending practitioner will propose a cause of death if they can do so to the best of their knowledge or belief. And this is a simplification of the current, or rather the previous rules that enabled medical practitioners to be an attending practitioner and complete the MCCD only if they had attended the patient during their last illness, but required a referral of the case to the coroner for review if they had not done so within 28 days prior to the death, or had not seen in person the patient after death. So this is a simplification. Second change relates to information about implantable devices, and that must now be recorded on the MCCD by the attending practitioner. And the final change, and for our purposes the most important, relates to the role of the medical examiner. And under the new system, an ME provides independent scrutiny of the cause of death proposed by the attending practitioner. And so the main change is that the attending practitioners must share the MCCD and proposed cause of death with a medical examiner who will scrutinise these before submission to the registrar. Medical examiners, so who are they? A medical examiner is a senior medical practitioner who is contracted for a number of sessions a week to provide independent scrutiny of causes of death outside of their usual clinical duties. They are required to be trained in the legal and clinical elements of death certification processes and will not have been involved in caring for the patient. Medical examiners have been carrying out independent scrutiny of causes of death since implementation of the non-statutory medical examiner system, which was gradually rolled out over the last couple of years. But now independent scrutiny has become a statutory requirement prior to the registration of all non-coronial deaths in England and Wales. Their role is to provide independent scrutiny of the cause of death, give bereaved people an opportunity to ask questions and raise concerns with someone not involved in providing care to the deceased person prior to their death, and undertake a proportionate review of medical records and work with doctors to complete the MCCD to help ensure this is accurate and to highlight any concerns about the person. Now, these requirements are set out in the MCCD regulations 2024, which is one of the 3 that was on the earlier slide. But one of the crucial safeguards for families, in my view, is Regulation 8, which requires the medical examiner to discuss the cause of death with a person who, in the terms of the regulations, is qualified to give information concerning the death under the 1953 Act, which in short is a range of people, but importantly includes relatives and any person present at the death or any occupier or inmate of the house where the person died who knew of the happening of the death. And the research that has been done so far suggests that this is working quite well. Families have commented things along the lines of that speaking to someone not involved in care empowered them to say what they really felt. Others have said that the medical examiner office kept them informed about an unfamiliar process. Evidence presented to the Royal College of Pathologists, for example, who are the lead medical Royal College for medical examiners, it also included the positive impact of the independent medical examiner in rural areas, for example, where a GP certifies the death and members of the family all have the same GP and so don't want to be seen to be saying anything negative. By having access to a medical examiner who is separate and independent from the doctor who fills in the certificate, members family members found it easier to raise any concerns. Once the relevant attending practitioner and medical examiner have completed their declarations of certification and scrutiny, and the cause of death is confirmed, then the MCCD will be sent to the registrar by the medical examiner rather than the attending practitioner. And the representative of the deceased will be notified at the same time that they can now contact the registrar to arrange the registration of the death. So all of that said, when do deaths go to the coroner? There are basically two circumstances. One, where the attending practitioner is not able to establish the cause of death, or the ME feels unable to confirm the cause of death. And two, where the circumstances giving rise to the duty to notify under the notification of deaths regulations applies, either in the view of the attending practitioner or in the view of the ME. The notification of death regulations lay down a duty to notify the coroner of a death in a list of circumstances. And a person's death should always be notified to the coroner where there is reasonable cause to suspect that the death was due to any of the following. And due to means more than minimally, negligibly, or trivially caused by or contributed to. So due to any of the following: poisoning, including by an otherwise benign substance, exposure to or contact with a toxic substance, use of a medicinal product, use of a controlled drug or psychoactive substance, violence, trauma or injury, self-harm, neglect, including self-neglect, the person undergoing any treatment or procedure of a medical similar nature, an injury or disease attributable to any employment held by the person during a person's lifetime. In addition, a person's death should always be notified to the coroner where any of the following 5 bullet points apply. The registered medical practitioner suspects the person's death was unnatural, but it doesn't fall within any of the above circumstances. The cause of death is unknown. The registered medical practitioner suspects that the person died whilst in custody or otherwise in state detention. There is no attending practitioner, or an attending practitioner not available within a reasonable time to sign an MCCD, or the identity of the deceased person is unknown. And the length of time that has passed since the person died does not impact on the duty to notify coroner of the death once relevant circumstances come to light. So that is a sort of skip through the reforms and the background. And so now, assuming that a referral is made to the coroner for whatever reason, what happens next? And I'm going to hand over to Harriet at this point. Thank you very much.
Perfect. Thank you so much. So thank you very much to Sam for that really interesting background to the new reforms. I, for one, hadn't quite appreciated how kind of historic some of that going back is. And I'm now going to be kind of picking up from where Sam left off and looking at some of the procedural routes from a case arriving with the coroner up into the inquest, with a focus on disclosure. And then I will also be moving to very briefly talk about the role of counsel to the inquest and challenging coronial decisions. So turning first to procedure, the usual procedure would be to open the inquest as soon as possible after the death, and then postpone the hearing so that, for example, families can have a funeral. This is Rule 5 of the coroner's inquest rules. And then what happens next is usually the evidence gathering phase begins. And usually the inquest hearing itself wouldn't happen until those investigations are complete. So two key areas to look at for the evidence gathering phase. Firstly, Schedule 5 to the Coroner's and Justice Act. And then we've got Part 3 to the Coroner's Inquest Rules. Schedule 5 is what sets out the power of the coroner to require evidence to be given or produced. During an investigation, the coroner can require a person to provide evidence and produce documents that are in their custody or control, which relate to a matter relevant to the investigation. And that schedule also provides a power for the coroner to require that person to give evidence at an inquest and to produce documents in their custody or control, which would be relevant to the inquest. Just pause there to note Schedule 6, paragraph 7.2, which is that it's actually a criminal offence to intentionally suppress or conceal a relevant document. And I think that's why, in particular, it's important if you're acting for an IP to keep a good record of your disclosure process, particularly in inquests, which are very document heavy or particularly complex in terms of disclosure, because obviously that will be particularly important if there's, for example, an accidental failure to disclose. Part 3 then of the coroner's inquest rules, this is disclosure of documents by the coroner during or after the course of an investigation, pre-inquest review or inquest, and that's going to interested parties. And the key point here is that the onus is on interested persons to request disclosure from the coroner, and the coroner must then disclose as soon as reasonably practicable. But the coroner can refuse to disclose certain documents. Have a look at Rule 15 for that. The circumstances they can refuse would be legal prohibition on disclosure. They can't get consent of an author or copyright owner. The request is unreasonable. It relates to contemplated or commenced criminal proceedings, or that it's just irrelevant to the investigation. And I paused there at that stage to note the Worcestershire decision, which of course many of you will be familiar with. In that case, a distinction was drawn between, on the one hand, disclosure to the coroner, and on the other hand, disclosure to the public. In that case, there was an argument about whether a local authority had to disclose to the coroner the underlying reports beneath a serious case review, in addition to the actual report itself. And what was held there is that disclosure is a two-stage process. So stage 1, the coroner decides the scope and the witnesses to be called, and they can request a wide range of disclosure to do that. And stage 2 is when the coroner decides whether there can and should be onward disclosure to interested persons. And it was said that at stage 1, in that case, as the disclosure was to the coroner rather than the public, the High Court held that the public interest in having a full and appropriately detailed inquest outweighed a claim for non-disclosure by the local authority. And so there are contrasting views about the Worcestershire decision, but I think it's fair to say, given particularly now that we have Law Sheet 3, it does seem, for the time being at least, to be firmly entrenched in sort of coronial practice. Once you've had your disclosure, or partway through disclosure, more likely in practice, you will usually have a pre-inquest review hearing, particularly if it's a more complex inquest, and Rule 6 of the coroner's inquest rules is the relevant one for that. It's a case management hearing following typically standard agenda items that are very helpfully set out in the guidance note. Usual issues would be identity of interested persons, scope, Article 2, jury, witnesses, further investigation and experts, disclosure, practical matters like length of inquest, date, and venue. And just pausing there to kind of give some tips about the pre-inquest review. Firstly, just making sure that an agenda has been circulated so that you can be fully prepared for the issues that are going to arise. But I think the key point is that the PIR is not an opportunity to be overlooked. The coroner is quite unlikely, in my experience, to have been read in on the minutiae of the case. Coroners are hugely busy, dealing a huge amount of cases, and the PIR will be a relatively short hearing quite far in advance of the actual inquest. So it's unlikely they're going to be up to speed fully in all the detail of the case. So it's up to you or your counsel to direct them to points of detail. And this is the time when you can have those arguments about the really contentious issues. Article 2, for example, further disclosure, scope, experts, and being sort of extremely well prepared coming into that hearing, ideally, if you can, with short, focused written submissions, can be really useful for getting those items kind of resolved at a very early stage, rather than, for example, letting those issues plod on through a number of PARs and potentially even turning up to the inquest and having issues unresolved, which is obviously going to go down very badly. So that's my 2 cents on the pre-inquest review. And then we get to the point where the PARs are done. In an ideal world, you've got your disclosure, those kind of PR issues are ironed out, and we get to the inquest itself. That's when it will be for the coroner to call the evidence, and law sheet 5 is where to look for that. That makes clear that the coroner has a wide discretion in terms of calling witnesses, and it's pretty much for the coroner to decide how to deduce the necessary evidence, what cross-examination is permitted, and what evidence is considered relevant. And that wide discretion will only be interfered with by the courts on a Wednesbury unreasonableness basis. So that has been a very brief canter through some procedural points. I'm just going to pause there to do a shameless plug for the fact that Sam, Catherine and I are going to be doing another webinar in November on Article 2 specifically, because obviously that's one of the really meaty points that can be argued out at the PIR stage. So please do join us for that if you can. Turning then to counsel to the inquest. Interestingly, coroners have been appointing barristers to act as counsel to the inquest since at least the 1980s, but it's become far more common in the past decade or so. But despite that, that kind of long-standing history, counsel to the inquest isn't recognised as a role in the Coroners and Justice Act or the inquest rules. And the first official mention was in 2020, when we had Guidance Note 40 published on counsel to the inquest. And that's a really useful starting point. In many ways, CTI is very similar to the role of counsel to the inquiry in a public inquiry. They're independent and can advise the coroner on issues such as scope, disclosure, and requests for witness statements. They can assist with preparing for pre-inquest reviews, and at the inquest itself, they can examine witnesses and provide submissions on the conclusions that might be open at the end. So when might instruction of counsel to the inquest be beneficial, and what types of cases would benefit? Historically, it's been very large inquests, which are very complex, have a very large number of witnesses, or have voluminous documentation. And it's typically that type of inquest which essentially almost resembles a public inquiry. So, for example, the Hillsborough, Litvinenko, Deep Cut. But I think it's fair to say that in recent years, it's being increasingly seen as a flexible resource, which doesn't have to be limited just to those cases, particularly, I think, in the current climate where senior coroners' workloads are increasing. And in those circumstances, CTI can be kind of a cost-efficient and flexible way to have assistance. I think it's important to remember they can be instructed not just for the whole case, but also just for smaller parts. And in terms of tips for working with CTI, if you're for another IP, well, I think that's hugely useful. I think it's a fantastic thing usually if you're for another IP, because if you can build up at an early stage a good working rapport with CTI, that can be an informal way in which you can, for example, streamline case management by kind of working out what the key issues are going to be. You can work with CTI to try and narrow or avoid legal disputes. Coroners' officers can be hugely busy and overworked, often can take some time to get back to you on queries, whereas CTI will typically be a quicker route for you to get answers, and essentially they can really act as a kind of first port of call for informally raising issues or gauging the coroner's provisional or likely views on matters. So yeah, a very helpful resource if you use it wisely. Could I have the next slide, please, Anushka? The next point I'm going to be talking about is challenges to coronial decisions and conclusions. So, unlike many other types of proceedings, there's no statutory right of appeal following an inquest, and instead you've got two paths you can go down. On the one hand, an application under Section 13 of the Coroners Act, or the JR route, and you can either do those individually or concurrently. So statutory review, that's the Section 13, and that is where a coroner refuses or neglects to hold an inquest, or where it's necessary or desirable in the interest of justice that an investigation should be held, or another investigation. And if the latter, so if it's the second part, investigation should be held or another investigation, the grounds set out there would be fraud, rejection of evidence, irregularity of proceedings, insufficiency of inquiry, and discovery of new facts or evidence. And then interestingly, it says or otherwise. And there's case law on the fact that or otherwise doesn't just mean boundless in scope. I think it's the reasons given give you an idea of the types of thing that's going to qualify here, even though they're not exhaustive. Judicial review, that will be on usual public law grounds. So challenges to coronial decisions again, looking now, I'm just going to go through at some key differences between those two routes, because obviously if you're faced with a case and you're trying to work out what the best route to challenging it is, these are the kind of considerations to weigh up. So the main difference, I would say, probably the one that's likely to be the most important, is the difference in scope and application between those two routes. Section 13 is essentially providing you with a way to quash determinations or findings, and it's relating to the decision to have an investigation or inquest, or whether to have another one. Judicial review is much wider in scope. You can use that to challenge essentially pretty much all decisions and all actions and decisions of the coroner, including, for example, preliminary or interlocutory decisions. So that can be a very helpful tool there. And if you're in that situation, JR will be the way you should go, not Section 13. Time limits, it's a small point, but it can be important in practice. So judicial review, you're stuck with the usual 3 months after the date on which the grounds first arose. That can't be extended by agreement between the parties. Whereas Section 13 has no time limit, providing that the relevant conditions are met. But interestingly, there was a case, Jones and Coroner for Gwent, which basically said that Section 13 shouldn't be used as an attempt to JR by the back door when you've not brought a timely application for JR. So there will be a bit of a distinction there between if it really should have been a JR, then that's the route you should have gone down. You can't just fail to bring a JR, wait around, and then think, oh, I've got unlimited time to bring my Section 13. That's not going to go down too well. Procedure, JR, just the usual JR procedure. Section 13, you need to apply for permission from the Attorney General for what's called a fiat in order to proceed. That is a test pretty similar to that applied on applications for permission for judicial review. And then relief, so Section 13, you can have the High Court ordering an investigation be held, the coroner to pay costs of the application potentially, an inquest, where an inquest has been held, you can quash a determination or finding made at that inquest. Judicial review is a bit more flexible by contrast in terms of relief. And an interesting point to note is that they can quash the inquest and order a fresh one, but they can also grant relief falling short of quashing the entire inquest. So crucially, they can substitute a conclusion, add a narrative, or delete the conclusion and remit it back to the coroner to re-enter a conclusion in light of the judgment on the JR. So that can be, in some ways, that can be a quicker way to get to the conclusion that you want. So the million-dollar question, which one is best? No superior route, I don't think. It's going to be turning on the facts, essentially, which is going to be the best course of action. Whilst in some cases, the quite broad prerequisites to Section 13 and the lack of time limit might be attractive. In other cases, just the breadth of decisions and actions that can be reviewed and the flexibility of relief in a JR will be more appealing. And I just wanted to finish with two 2024 decisions, just to illustrate how these challenges are working in practice, to just give you a bit of context. So firstly, there's the decision of Senior Coroner for Sefton, Knowsley and St Helens and Kay. This was a Section 13 review example. It's maybe slightly unusual in some respects in that it was the coroner that applied under Section 13 for a previous inquest to be quashed and for a fresh inquest to be ordered. In this case, essentially, tragically, the deceased had been found dead in their bed in October 2020 with an empty packets of prescription medication next to her. An inquest took place in February 2021, and cause of death was recorded to be bronchopneumonia and mixed drug toxicity. But in March 2021, the coroner was made aware of what appeared to be suicide notes written by the deceased, and of the fact that the deceased medical records disclosed a history of suicidal ideations, including intentional overdosing. And the coroner hadn't been made aware of that information at the time of the inquest. The court confirmed that the proper approach to Section 13 was as set out in the case of Sutovich, which you'll find if you go to the K decision, and emphasised that the possibility that the possibility of a different verdict and the need to investigate matters raised by new evidence and shortcomings in the original inquest were all matters of central importance. It was not essential that a different determination was probable, but likelihood was a relevant factor. So that's an important point to note for any future cases you might be considering. And the factors which were relevant here when deciding to hold the new inquest were new evidence and possibility of a different decision, families' wishes, time lapse since the original inquest, and delay in applying for a fresh inquest. And the court held the inquest should be quashed, a fresh inquest ordered, and the application under Section 13 was granted. And just finally, by contrast, to give you an example of a recent JR, this was the case of Brian. It was a judicial review of the coroner's conclusions in respect of the tragic death of a mother and her daughter. The very sad circumstances were that a mother had jumped onto a train track, holding her daughter in her arms, and both were very sadly killed. The coroner had returned a short form conclusion of suicide in relation to the mother, and a lengthy narrative-only conclusion in relation to the child. Which was included the fact that it was not possible to determine that the mother was not suffering from such disease of the mind as to be incapable of distinguishing between right and wrong, and was therefore likely to be legally insane. And the JR was brought on the basis that the coroner had erred in law in adopting a presumption of insanity in relation to the mother. And they argued that the any conclusion other than the fact that the child had been unlawfully killed was irrational. But this judicial review was refused, and some useful guidance on insanity, which was that there were two key questions. One, whether on all the available evidence the issue of insanity was properly raised, and if so, is there sufficient evidence of insanity for it not to be withdrawn from consideration, either by the coroner or, if there is one, the jury? And secondly, whether on the relevant evidence the correct conclusion on the balance of probabilities was that the person in question was not insane. And in terms of the conclusion reached, the court said that the case was detailed, sensitive, and complicated. And in those circumstances, the decision to give a narrative conclusion had been fully justified. And they said that whilst it had been less than immaculately expressed, because it had introduced a clunky double negative, using the court's words, they found that the findings of the coroner were nonetheless reasonably clear and within the bounds of the conclusions open to him on the evidence. So those are just two examples of recent cases. Oh, I apologise, the slides haven't been moved on. I'm sure they'll be available afterwards. Thank you very much. I'll just now hand back over to Sam, and we'll just see if we've got any questions in the remaining 1 or 2 minutes that we have left.
Thank you very much, Harriet. That was extremely interesting and useful. And I can certainly say that I've had a CTI in my court when I've sat as a coroner, and it has been absolutely brilliant. And a CTI can, in fact, have an incredibly useful role as a sort of, not negotiator is the wrong word, but as a way of really getting from the parties what the real issues are between them and streamlining the process. So it's a really valuable thing, but obviously has resource implications. But if you end up in a case where there is one, that is a really excellent position to be in. So I think we've had a question for you, Harriet, actually about costs following a challenge to a coroner's decision.
Yes, so somebody has asked essentially what the position on costs is in a JR versus a Section 13. That's a really good question. Section 13, it's essentially just a power to award costs as may appear just. It's pretty much, though, if they were neutral on the matter, it's unlikely that those costs are going to be awarded. Judicial review, it's in a way a similar position. If the coroner is just neutral and not assisting, just assisting the court, it's most likely it's just going to be no order as to costs. It would only be if the coroner sort of waded in unreasonably and lost, that it would be likely in those cases for the cost to follow the event.
Yes, great. Thank you. I can also see that we've got a question from an anonymous person saying, hi, do the reforms apply to deaths since this 9th of September or to investigation commenced from the 9th of September? That's a good question, but I think the answer, and I will correct it subsequently if I'm wrong, but I think the answer is that deaths from on and after the 9th of September. And then somebody's asked whether it's possible to have the notes from this presentation. Yes, they will be emailed out along with a link to the video. So that will happen within the next day or two. And then finally, there's also a question about a duty to disclose. Is there a duty to disclose engaged if you are not an interested party? What powers does the coroner have to penalise a non-interested party for failure to disclose in the absence of a Schedule 5 notice? Oh, there's various layers to that question, and I'm not entirely sure whether the question is relating to interested parties specifically, because coroners have powers to request information from a variety of people, including people who are not necessarily interested parties. And so, yeah, maybe we will come back to interested parties and further duties of disclosure due course, unless you want to add something to that now, Harriet.
No, I think we could probably do a whole talk about that. So
Okay.
yeah, that's fantastic. Thank you, Sam.
All right. Well, that's great. Thank you all very much for attending. Thanks for the questions, and maybe we will see some of you next time. Thanks. Bye.
Thank you.